Thank you for tuning into our channel African Dignity. This is our continued lesson on bail. We have spoken about the procedure that is followed in bail, and I have told you that during bail application, you can put your applicant, your client, on the stand. But what I don't like about that procedure is the fact that you are exposing your client to cross-examination by the prosecutor. So I always prefer that during bail application you read an affidavit to the record. And what is also very important is that after you have read the affidavit, you must hand it in as exhibit. It will be recorded as an exhibit. Please do not forget that if you do practical in class, or you are asked to explain the procedures during bail, you must state that after you have read your affidavit that has been made by your client, you say this is the applicant's case, and after that you request that the statement be handed in. How do you do it? You will say, with the leave of the court, may I hand in the applicant's affidavit as an exhibit. Then you'll give it to the officials in court, because you are standing right in front of the master. You can't leave the bar, that is now where you are standing, and go and give the statement to. You will just pass it to the nearest person until it gets to the magistrate. Because if you move from the bar is exactly where you are standing. You need to seek permission from the presiding officer. So you've done that we know. Now let us deal with the procedural and evidential rules relating to bail applications. Because in our course outline, we all know that we've got trial procedures and the applicable rules in as far as evidence is concerned. So we will deal with the evidential rules when it comes to bail application, right? So what is important is that we need to make a distinction in our courts about what is known as accusatorial and inquisitorial role of the court, right? So those roles are different. Inquisitorial will be where the magistrate is the one that is doing all the inquiry, asking all the questions in order to get to the core of what is being discussed. So it will be the magistrate asking many questions. But in the accusatorial, this is the process that is used in our courts. It is accusatorial, right? It will be the public prosecutor who is asking questions, who is leading in the court. Everybody will be subject to his directions to say, this is what we are going to be doing today, and he is the one who is accusing the accused before court. He will be the one preferring the charges and explaining to the court as to what transpired, what brought about that the accused is now being charged of the offense in question. So Now let us deal with the procedural and evidential rules relating to bail applications. Right. Here we talk of inquisitorial role of the court. Right. In bail applications, the court, which is now the presiding officer, has to be proactive. That means inquisitorial. He will be the one asking the questions, asking for clarity from all parties. That is the applicant before court and the public prosecutor. The court hearing bail application should act. It should act as it should act as proactive as possible. You cannot afford to be passive if you are presiding over a bail application, right? If you look at the constitutional court decision in the case of Dlamini, and also in the case of Matonzi. The case of Matonzi, the citations there will be 2016 volume 1, South African Criminal Reports at page 417. It's a Gauteng Province Court, right? I think it's a South Gauteng. So if you look at that case, then you will see that even the Constitutional Court decision in the case of Dlamini is pro the fact that the court should be posing all the questions in order to get clarity, right? And if the question of the possible release of an accused on bail is not raised by the accused or the prosecutor, the court should meromutu ascertain from the accused whether he wishes to be released on bail, right, or he wishes that his release on bail be considered, right? That is now in terms of section 60, subsection 1, subsection C, right? And also in the case of Ngwenya, it was raised that if both the defense or the defense or the applicant's representative and the prosecutor do not raise the issue of bail, the court has to take charge and raise that question. This was also raised in the case of Ngwenya. It's a 1991 case, volume 2, SACR at page 520. You will find that. Okay. And also, apart from postponing bail proceeding is provided for in section 60, in section 50, subsection 6, and explained also, as I've just explained, the court may, in respect of matters which are not in dispute between the accused and the prosecution, acquire in an informal manner the information that is needed for its decision or order regarding bail. So that it is now upon the court, right, to find out in an informal manner, right, and get all the information that will be needed, so that it will be in the interest of justice to release the applicant or the accused or on bail, right? Or the accused as well may be allowed to accuse evidence. That is now in section 60, subsection 2C, right? And the court has the power to decide who should lead evidence. So the court might say, okay, Mr. Prosecutor, you should lead evidence. That is now the prosecutor calling maybe the investigating officer to come and lead evidence as to or the reasons as to why they oppose bail. Or the court may order that the accused be placed on the witness stand so that he can be cross-examined. It will depend. But if you are an attorney representing that accused, you have all the power to choose what will happen. If you have prepared an affidavit, the court cannot say, no, I don't want an affidavit, because it serves the same purpose. The only difference is that the affidavit that you make from the bar and read it to be recorded in the court proceedings doesn't carry more power as the statement that is made by the accused or the applicant on the witness stand, because there he will be sworn, right? He'll be sworn in, and also he will be subjected to cross-examination. So whatever he says there, it's under oath, and he is subjected to cross-examination. It will then carry more weight than any other evidence. All right. Where the prosecutor does not oppose bail in respect of matters referred to in Section 60, subsection 11 of the Criminal Procedure Act, that is subsection A and B, the court must require of the prosecutor to place on record the reason for not opposing bail. So if now you go to court and the prosecutor says, no, we are not opposing bail, it is the duty of the presiding officer to ask the prosecutor to put on record as the reason as to why bail is not opposed, right? This is another inquisitorial feature of bail proceedings. Like I've told you that the magistrate takes charge in bail applications, right? So he has a duty to find out what was the reason, because the public out there might suspect that there has been foul play, and sometimes people are busy toying in the perimeters of the court, and the next thing they see is the accused walking on the street, and the court is now brought into disrepute, as to say that we police arrest people and the court just release them. So it is important for the prosecutor to state the reasons as to why bail application is not opposed. But it's good for the attorney, because all you do once they say bail is not opposed, then I advise you not to put your client on the witness stand, and subject him to cross-examination, because he might say something that will jeopardize his chances of getting bail. So the best thing you must do is to just read the sworn affidavit to the record, and state that is the applicant's case, and you hand in your statement for the court to record it as an exhibit. Okay, right. In bail proceeding, the court should not play a passive role, upset that in the presentation of evidence. This much is clear from Section 60, subsection 3 of the Criminal Procedure Act, which provides that if the court is of the opinion that it does not have reliable or sufficient information or evidence at its disposal, or that it lacks certain important information to reach a decision. On bail application, the presiding officer shall order that such information or evidence be placed before court, right? That is now in terms of section 60 subsection 3. The traditional adversarial right of the parties to be selective in their presentation of facts in support of their respective cases has been curtailed by section 60 of the Criminal Procedure Act. That is now section 60 of subsection 3. And then a further active role is given to the court by section 60 subsection 10, right? This interest of the accused against the interest of justice, right? Despite the fact that the prosecution does not oppose the granting of bail, but the court has a duty to weigh between the interest of the accused and the interest of justice, because there are people out there who are watching the proceedings, and maybe they could be in the gallery, or they could be out there at the gates of the court and making that noise to say no bail for killers. So it is important for them to know exactly what was the reason. You can see the case of the Procureur General Freistaat versus Ramokosi. It's a 1997, volume 1, SACR, at page 127. It's an Orange Free State case. So you must look at that case, and it will explain. You'll just look at the principle there, right? However, the fact that the court is required to play an inquisitorial role in a bail application does not entitle it to resort to unfair and excessively robust questioning of the witness, including a bail applicant who elected to testify orally in support of his application. Look, you can see the case of Gade. It's a 2007 case, volume 3, all South African reports, at page 43. That just because the law allows the court to play the inquisitorial role, it doesn't mean that it should be very harsh on the witness or the accused, or maybe also order that the accused must pay hefty bail money, because if you do that, then it is as good as refusing bail. Because if you take that on appeal and you say that the presiding officer ordered the applicant to pay hefty amount of bail money, then that will amount to bail denied. And when you're denying bail, you should also state the reasons why the bail is denied. Because, like I've said, here we rely on hearsay evidence, right? Okay, let us come to the concept which is known as the free application of evidence, which is the application of a free system of evidence. You'll recall that evidence is governed by the law of evidence of South Africa, which includes hearsay evidence, viva voce evidence, and all of that, and evidence which is reduced to writing, right? Now we are dealing with evidence in respect of bail application, right? The strict rules of evidence are relaxed when we deal with the bail application. Here, evidence may be received more readily than at a trial. A case in point that supports that argument is the case of Maharaj. The citation is 1976, volume 3 SA at page 205. It will tell you about, if you have an argument with the presiding officer as to whether hearsay evidence is admissible or not in court. Because sometimes you'll find that, okay, the magistrate knows, but your opponent, which is maybe the attorney or the prosecutor, depending on what role you are playing, will raise the point that hearsay evidence is not admissible in our law. Then you need to say hearsay evidence is admissible or only in bail application, right? However, a careful assessment of such evidence is necessary. So you need to assess that evidence as well. Don't allow people to just come and tell a blatant lie and say just because hearsay evidence is allowed, then you accept it. In Makungu versus Assistant Magistrate at Whittlesea, the citation of the case is 1977, volume 2 SA at page 359. It's an Eastern Cape case. The court refused to rely on a young constable evidence that he had received information that the accused were planning to flee. The source of the constable's information was an informer whom he had lawfully declined to identify in terms of the informer's privilege. There's something called the informer's privilege, where you as an investigating officer, you or a prosecutor, you are not allowed to reveal the identity of that because it is privileged. So you cannot say, no, I had informer so-and-so told us, telling me that this is the situation, because what will happen, you are putting that informer's life at risk. He might be killed. But there are obvious risks in relying upon hearsay of this nature. So that is why it is the duty of the court to examine that hearsay evidence and try and verify some issues around it, right? Because there's a problem with something called ex parte statements. I know that most of you do not understand what is meant by ex parte, right? Let me explain it and make it simple for you. When you finish your LLBs, and do your article, do your PVT, which is practical vocational training, and you do your articles, you finish your articles of clerkship, you will do an application to the High Court. It's only done in Pietermaritzburg. That application is an ex parte application. It's called ex parte because there is only one party. There is no two parties. Once there is only one party, and that party will be you applying to be admitted as an attorney, you will make what is called an ex parte application, right? So ex parte statements or oral statements made by the defense and prosecution from the bar may be received, as it is desirable that application should be dealt with expeditiously. So you will take that statement. You will take the statement, admit it, because the reason is that you want to deal with the bail application expeditiously. So you cannot waste time and say we will wait for a witness who is in Johannesburg, and yet forgetting the interest of the person who is being incarcerated and who is desiring to be admitted to bail. So it is important that those statements are admitted, and make sure that there is no delay in dealing with the matter, right? Sometimes when the accused does not have a legal representative, this may also tip in the balance in favor of informality. Well, that is now where the accused does not have an attorney. So the presiding officer can do that in an informal way, right? Just to ask the questions. That was the case in the case of NICAS, 1977, volume 1 SA at 257, and also at page 261, A to B. However, this is easy-going procedure, and it has some advantages, right? Very little of substance is on record in the event of an appeal, and expert statements also carry less weight than oral evidence. Oral evidence on oath is preferable. That was the principle that was used in the NICAS case, right? If you look at page 262 of the same case, I've given you that citation of 1977, volume 1 SA, but also look at 262 from paragraph F to G, right? Because the witness consent can then be cross-examined, then it carries weight, and the witness is under oath as well, so it will carry weight than evidence that where somebody says, I heard so and so saying. So you need to be to take note of that. This advantage inherent in oral evidence does not mean that a court may disallow affidavits. So that just because the court says do oral evidence, then like I've said, the court does not have the power to say do not do the affidavit, the sworn statement, like how we did in class. So the court cannot say that. All right. Also, the court may, depending upon the circumstances of the case, rely on the opinion of the investigating official. For example, the opinion that the accused will interfere with the state witnesses. That was the issue in the case of Hlongwa in 1979, volume 4 SA at 112. The court relied on the statement of the investigating officer, who says he is sure that the accused, when released on bail, he will interfere with the witnesses, right? So so the court allowed that to be the case, yes. And also in the case of Lucas 1991, volume 2 SACR at page 429. That was also an Eastern Cape for the Grahamstown case, and at page 437 B to C. It was, however, warned that a court should be astute not to simply accept the ipsa dixit of the investigating officer or other policemen who testify on behalf of the state, and should consider the possibility that such witness may have an improper motive in opposing bail. So that is why, when you as a presiding officer, you need to do a thorough investigation or a thorough questioning of the witnesses to find out as to why do you say, like the case that I told in court, where people, in class, where people said the accused should not be released on bail because the people are toying and are saying they are going to kill the accused. So the question is, do you know who has been threatening to kill the accused? And maybe the police officer will say, no, I don't know. And maybe we can ask, did you see the mayor? Toying there? And in my case, the policeman said, yes, I've seen them. I said, then you know who is threatening to kill this accused. So as a policeman that dispenses justice without fear or favor, because the mayor has threatened, like you're saying under oath, has threatened to kill the accused, you have a duty to arrest the mayor for intimidation and threatening to kill or inciting violence against this applicant. So that is why now you need to help the court, is that when they make that statement, you interrogate the statement. Don't just take any statement lying down. Interrogate it and make sure that it makes sense. On the other hand, due consideration should be given to an accused's testimony as well, that he has no intention of absconding, right? That was the case in the case of Hudson, 1980, volume 4, SA at page 145, right? Still, greater reliance cannot be placed on an accused mere ipse dixit to the fact that he will not abscond, since an accused who has such an intention is hardly likely to admit that I intend absconding or running away from the law. Ipse dixit means the word of mouth. So you need to be careful. You cannot just allow it just because he said so under oath. Then you believe that. You need to interrogate and find reasons as to believe that he will abscond.